India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. Delhi High Court expresses concern over a sharp spike in COVID-19 cases in Delhi, slams government for overlooking ground reality, says caution thrown to winds. Writ filed in the Allahabad High Court seeking removal of Mathura, Shahi, Idgah Mosque allegedly built on Krishna Janmabhoomi. Patna High Court acquits death row prisoner, setting aside conviction for murder on grounds of weak circumstantial evidence, says residual doubt becomes a factor for commuting sentence. Indore bench refuses to quash the FIR registered against Ekta Kapoor in connection to alleged obscenity and dishonour to national emblem in the series title. XXX says a case is made out.
India Legal presents Courts Roundup.
The Delhi High Court has expressed concern over a sharp spike in COVID-19 cases in the capital city and remarked that the Delhi government has remained oblivious to the ground reality and that has thrown all caution to the winds. A bench of Justice Hima Kohli and Justice Subramaniam Prasad wrapped the government for continuously relaxing norms for movement of people even when there has been an exponential rise in the positivity rate. A city-state is like Delhi has been reporting far more cases than states like Maharashtra and Kerala. No household has been left untouched. However, it has been noticed that even in such a critical situation, the Delhi government has continued to relax the norms relating to movement of the public, it said, and the bench has therefore enlarged the scope of hearing in a petition filed by one Rakesh Malhotra seeking ramping up testing facilities in Delhi. The bench has now directed the Delhi government to file a status report setting out the steps taken by it in the past 2 weeks to control the COVID-19 infection and the manner in which it proposes to deal with the other issues flagged during the course of hearing. The court noted that despite worsening of the situation in Delhi, both due to COVID-19 and air pollution, the government had proceeded to increase the number of guests permitted at marriage ceremonies from 100 to 200. Similarly, as against the permission granted earlier to occupy alternate seats in public transport, the Delhi government permitted seat in public transport to be fully occupied. The court also made remark against testing through RAT and stressed that RT-PCR testing must be ensured. The Attorney General of India, KK Venugopal, has granted his consent for initiation of contempt proceeding against comedian Kunal Kamra over his tweet about the Supreme Court in the wake of its order granting interim bail to Arnav Goswami. Finding Kamra's tweet to be highly objectionable, the AG granted his consent under Section 15(1)(b) of the Contempt of Court Act 1971 to initiate criminal contempt. He said, I find that today people believe that they can boldly and brazenly condemn the Supreme Court of India and its judges by exercising what they believe is their freedom of speech. But under the Constitution, the freedom of speech is subject to the law of contempt, and I believe that it is time that people understand that attacking the Supreme Court of India unjustifiably and brazenly will attract punishment under the Contempt of Court Act 1972. The AG's letter referred to Kamra's comments such as honor has left the building, Supreme Court long back and Supreme Court of the country is the most supreme joke of the country. The AG also noted that apart from this comment, Kamra posted a picture of the Supreme Court dressed in saffron color with the flag of the ruling party, the Bharatiya Janata Party. A writ petition has been filed in the Allahabad High Court seeking removal of a Mathura Shahi Idgah Mosque allegedly built on Krishna Janmabhoomi. The petition filed by advocate Mahek Maheshwari seeks that the temple land should be handed over to the Hindus and a proper trust for Krishna Janmabhoomi Janmasthan be formed for building a temple on the said land. In the interim, the plea seeks permission for Hindus to worship at the masjid on certain days in a week and on Janmasthan Day. Till the disposal of the petition, the plea alleges that Lord Krishna was born in Karagar of King Khan's and the place of his birth lies beneath the present structure raised by the Shahi Idgah Trust. It is stated that in 1968, the society Sri Krishna Janmasthan Seva Sangh entered into a compromise with the Committee of Management of Trust Masjid Idgah, conceding a considerable portion of property belonging to the deity to the latter. Disputing the legality of this compromise, the petitioner has submitted the Committee of Management of Trust Masjid Idgah entered into a legal compromise with the Society Sri Krishna Janmasthan Seva Sangh, and both have played a fraud upon the court. The plaintiff deities and devotees with a view to capture and grab the property in question. In fact, Sri Krishna Janmabhoomi Trust is non-functional since 1958. She has further claimed that existence of carved pillars and antiquities below the courtyard of the Shahi Idgah Mosque was reported by certain workers. In this backdrop, a prayer is made for court monitor GPRS-based excavation by Archaeological Survey of India of the disputed structure, allegedly built over Krishna Janmasthan. It is contended that masjid is not an essential part of Islam and hence the disputed land should be handed over to the Hindus for exercise of their right to freely profess, practice and propagate religions under Article 25 of the Constitution. And the Himachal Pradesh High Court has granted bail to a man accused of raping a minor girl on the ground that the girl had consented to the sexual intercourse. Although she could not have consented for sexual intercourse as well as leaving custody of her custodian, but for deciding the bail, her conduct is sufficient to grant bail to the petitioner. Justice Anup Chitrakara observed, and 20-year-old Rohit Sharma had approached the High Court seeking regular bail on the ground that the family of the girl forced her to lodge a false complaint to break their love affair. The court noted that the victim had informed the police that she knew the accused for the last 3 to 4 months and was in touch with him through Facebook as well as phone. She also informed the police that on 30th of October this year, they participated in a marriage where the victim stayed with him, where he indulged in sexual intercourse with her. Taking note of this, the judge observed, the court added that an analysis of the entire evidence does not justify further incarceration of the accused, nor is going to achieve any significant purpose. Usual conditions were also imposed. And in a judgment rendered, the Patna High Court acquitted a death row prisoner, setting aside conviction for murder. The bench of Chief Justice Sanjay Karol and Justice S. Kumar iterated that the quality and strength of the evidence and the case of the prosecution not only have a bearing on the decision of conviction or acquittal, but also very much of the quantum of sentencing. Residual doubt becomes a factor for commuting sentence, and especially when evidence is purely circumstantial. Judicial approach on the bench death penalty ought to be cautious. circumspect and careful, more so because the decision is permanent and irreversible. The bench stated that the trial court has ascribed the fact of the victim is an unmarried woman who was taken advantage of as an aggravating factor, which is a fact that has neither been proved nor alleged in the case. Such a stance reflects the paternalistic attitude of society towards women and who are always considered as a helpless victim. The court must be mindful of this. The court has also laid great emphasis on the collective consciousness of society and a call for maximum punishment as a legal remedy where vicious and brutal crimes are committed against women. The court also seems to be swayed by the fact that the victims are women, thereby meriting greater reparation for the crime. However, in this case, the alleged reason of the crime was with respect to the property dispute and not necessarily related to the fact that they were women. The court has failed to realize that the court are not oracles of public opinion and the role of the court is not to soothe public sentiment. Courts have to exercise restraint and first ensure the individual rights guaranteed by the Constitution are kept at a higher pedestal than public opinion, said the bench. Stating that a prima facie case is made out, the Madhya Pradesh High Court Indore bench refused to quash the FIR registered against Ekta Kapoor, managing director of Old Balaji, in connection to alleged obscenity and dishonour to national emblem in the series titled XXX. A single bench of Justice Shailendra Shukla observed that in order to determine as to whether a particular matter is obscene or not, recording of evidence may be an important exercise. As far as the present case is concerned, it cannot be stated outrightly that the impugned episode is not obscene. It held the court was hearing an application under Section 482 of CRPC filed by Ekta Kapoor, seeking quashment of FIR filed against her for allegedly spreading obscenity, hurting religious feelings and improper use of national emblems in her web show XXX Season 2. And Kapoor had moved the High Court, stating that she did not have any knowledge of the content of episode because she is not a producer or the director and her name is not reflected in the credit for the episode. Rejecting this argument, the High Court held that Kapoor, being the managing director of the platform on the show, was released. She is presumed to have knowledge about the contents of the episode, and Kapoor had contended that the internet is full of much more explicit form of obscenity and therefore much ado ought not to be made about the impugned material. She also argued that if at all any case is made against her, she cannot be prosecuted in isolated without impleading the company Alt Balaji as co-accused. It observed that this case is distinguishable from Antela Hada's case in as much as in this case it was not in the hand of a complainant to ensure that the company is also named as an accused. Describing the state of affairs as regard the people of tribal community within the state of Bihar as shocking, the Patna High Court last week expressed hope that the authorities wake up from slumber and come out of the structure plan for ensuring implementation of the constitutional mandate, including under Article 338A. The said article provides for a National Commission for Scheduled Tribes. The bench of Chief Justice Sanjay Karol and Justice S. Kumar was hearing a PIL by the Bihar Adivasi Adhikar Forum, highlighting the apathy and policy paralysis on the part of the government in fulfilling the constitutional goal and the fundamental duty of providing education to the children, more especially girls hailing from the tribal areas, falling within the hilly areas of District West Champaran. The bench proceeded to remind itself of the constitutional mandate provided under Part 4 of the Constitution of India, which promotes the educational and economic interest of the weaker section of the people and in particular of the scheduled caste and scheduled tribes. The government has assured of dealing with the problem on a proactive basis, ensuring that not only the institutions are allowed to remain operational and functional, but also the general populace sensitized of sending their children, more particularly the girls, to undertake and complete their education at least up to higher standard, that is 10th and 12th, and even thereafter. And the Karnataka High Court has directed National Law School of India University, Bangalore to conduct special repeat exams for a student who had errors in 18 subjects. Justice Krishna Dikshit observed this order, and after all, in a country like ours, if poverty is not a sin, being poor in intelligence too cannot be denial of opportunity that was made available to others similarly circumstanced would be discriminatory and arbitrary. It offends sense of justice and cause to the aggravate of heartburn. The petitioner, who enrolled at NLSIU in 2016, filed a plea against the university's decision to detain him in his third year of BALLB course on the ground that he had errors of paper. NLSIU resisted the writ petition by filing a statement of objection justifying its decision. The university contended that the student cannot be given the benefit of a special repeat examination under the academic and examination regulation framed in 2009, as a fresh AER was put in place this year. After considering the argument, the court acknowledged that the petitioner had a poor academic record. However, it is for such poor performers that AER 2009, which provided for the special repeat examination, was promulgated, the court noted. Single judge bench also averred that the case of the petitioner was also supported by the doctrine of promissory estoppel and fairness of public action. Justice Dikshit found no substance in the argument raised by NLSIU with respect to the delay in filing the said petition. On the basis of this observation, the court directed the university to conduct a special repeat examination for the subject in which the petitioner had filed within a reasonable time. And leading peaceful and non-violent procession is a fundamental right under Article 19(1)(a) and 19(1)(b) of the Constitution of India, the Kerala High Court observed while quashing criminal proceeding against former MLA Dominic Presentation. A criminal case offence under Section 143-147-283 of the Indian Penal Code was registered against a former legislator in 2018 for causing obstruction to the general public and vehicles by conducting the procession in allegiance to the Human Right Protection procession led by V.M. Sudhiran, KPCC President, in protest of arrest of two Dalit girls in Talseri. By filing a petition under Section 482 CRPC before the High Court, the ex-MLA contended that holding a peaceful and orderly demonstration by way of protest is an exercise of fundamental rights guaranteed under Article 19(1)(a) and 19(1)(b) of the Constitution of India. Taking note of this prosecution case, the court noted that there is no whisper either in the FIR or the final report that there was any show of criminal forces, any resistance to execution of any law or commission of any criminal offence, etc. Fourth clause of S141, though state about deprivation of the enjoyment of the right of the way, it should also be by means of criminal offence. Force. In other words, exercise of some criminal forces or illegal act is a condition precedented to attract the ingredients of unlawful assembly. So prima facie, for the final report and the FIR, there is nothing to attract the offence under any of the limbs of Section 141 IPC so as to constitute an unlawful assembly, Justice M.R. Anitha observed. The judge also noted that there is no clear and cogent material to disclose that obstruction was caused to any person in the public way due to the alleged procession led at the instance of the petitioner and the others. Therefore, the offence under Section 283 IPC prima facie is also not attracted. Regarding the contention that the act of demonstration is protected under Article 19, the judge observed that some meetings may be peaceful in the beginning and subsequently may turn violent. So a blanket protection cannot be given to all procession or marches under the guise of freedom of speech and expression, peaceful assembly under Article 19(1)(a) and 1(b) of Constitution. Each case has to be examined based on its own facts. In other words, it appears to be a peaceful and non-violent procession led by the petitioner and others. Hence, their act are well protected under Article 19(1)(a) and 19(1)(b) of the Indian Constitution. Well, that's all we have for this bulletin. Thank you for tuning in.
India Legal presents Courts Roundup.